The Lacrosse Tower Judgement is in. Let's have a look. Hello everyone and welcome to this episode of Heiser Says. Now, we've got the judgment for the Lacrosse Tower flammable cladding blaze down in Melbourne. And the owners have been awarded $5.7 million in damages. 5.7. So, this is quite a interesting topic because I read through the judgment and I've pulled out the interesting bits that professionals should be concerned about, particularly architects. So let's read through this article first to get a bit of an understanding. The owners of apartments at Melbourne's Lacrosse Tower in Docklands have won more than $5.7 million in damages in a lawsuit launched after a fire fueled by flammable cladding caused significant damage to the building in November 2014. The fire, which was sparked by a late-night cigarette butt left to burn in a plastic food container, raised up aluminium composite cladding on the building's exterior, but none of the approximately 400 people evacuated from the complex were hurt. A review by the Metropolitan Fire Brigade found the building's cladding was not compliant with combustibility requirements, and the building's appeal board ordered the cladding to be removed from Lacrosse in 2017. It was the first major building fire in Melbourne caused by combustible cladding, which is now a serious and widespread problem. Earlier this year, flammable cladding helped fire spread over several stories of the Neo 200 apartment complex on Spencer Street, and I will add the card to the video I did about that in YouTube. Renewed concerns over the use of combustible materials as cladding on high-rise buildings. The Lacrosse blaze caused millions of dollars of damage to the 21-story building, prompting apartment owners to launch legal action against builder L.U. Simon in a bid to recoup more than $12 million in damages. That claim for damages covered the cost for owners of replacing the non-compliant cladding, damaged property, additional insurance premiums, and anticipated future losses. In a decision handed down in the Victorian Civil and Administrative Tribunal by Judge Ted Woodward on Thursday, L.U. Simon was ordered to pay more than $5.7 million to apartment owners. However, most of the money would be paid to L.U. Simon by the architect, fire engineer, and building surveyor who worked on the project after Judge Woodward found they had breached contractual obligations. So this is what a lot of people in the profession and the engineers and architects and other professionals are interested in, why the judge ordered the three consultants here to essentially reimburse the builder. So, getting back to the article, design defects contributed to damage. In his ruling, Judge Woodward found the architects, Elberg Fraser, had failed to remedy defects in its design, specifically designs which allow the extensive use of aluminium composite panels on the east and western facades of the building. That caused the design to be non-compliant with the Building Code of Australia and not fit for purpose, he said in his 227-page ruling, which laid out how costs should be paid. He also found the building surveyor, Gardner Group, breached its agreement with L.U. Simon by failing to exercise due care when it issued the building permit in 2011 for those architectural plans. Thirdly, he found the fire engineer, trading as Thompson Nichols, failed to recognize and warn the builder that the ACP panels proposed for use on the building did not comply with the building code. So these are the issues that the judge found, and that it depends on how you take it. I'm going to go through the judgment and discuss just the intricacies of how everyone was procured and who's involved. But, spoiler alert, I think the judge is actually right. The cladding used on the outside of the building, known as Alucobest, was found to have been highly flammable and did not comply with the Australian building standards. As a result, he ordered that the three parties pay L.U. Simon a combined total of 97% of the damages owed to apartment owners. Gardner Group was ordered to pay 33%, Ellenberg Fraser 25%, Thompson Nicholas 39%. Smoker who sparked blaze escapes costs. The remaining 3% costs were attributed to Jean-Francois Gubetta, who was on a working holiday in Melbourne from France and whose abandoned cigarette sparked the blaze. But Judge Woodward found Mr. Gubetta's responsibility for the loss and damages was minimal and made no order directly affecting him. Instead, L.U. Simon was ordered to pay that share of the cost itself. Some of the $12.7 million sought by apartment owners is yet to be resolved. Judge Woodward said the calculated compliance cost of nearly $6 million sought by the owners seemed reasonable, but he made no order on the sum while the parties continued to negotiate the matter. The ruling may be closely followed by apartment owners across Melbourne, considering who will foot the bill to replace non-compliant flammable cladding on their buildings. However, Judge Woodward stressed that his ruling should not be taken as setting any particular precedent for bodies corporate more generally. These reasons should not be read as commentary generally on the safety or otherwise of ACP and their uses, he said. Many of my findings have been informed by the particular contracts between the parties in this case and by events occurring in the course of the Lacrosse project that may or may not be duplicated in other building projects. Now, having read through the judgment here, and we'll go through that in a minute, I would argue that yes, it has occurred in many other cases. So let's have a look at the structure or the parties involved. So initially we had, during the first stage of the project before they started construction, you had the developer here. And under him, you had the architectural practice. Okay, and you had the director, Callum, there, and then under him, David, was the architect, probably be doing most of the work. Now, the developer also hired or retained the building surveyor, so Anastasia Galanis, and of course there would have been other people advising on this stage of the project, but engineers and other consultants, but they were not party to this case, so they haven't been called upon. So I just want to kind of map out this relationship for you if you're not familiar with it. Now, traditionally, the architect would then become the supervisor of construction, and would have the builder there, and then they'd also have input from their own consultants to finish the drawings. Okay, but that's an old method that hasn't been used here. What happened is when we went to construction, or when the developer here, the client of the architect, pushed for design and construct, or wanted design and construct, so they asked for rapid documentation, we got this method here. I'm just checking down here to make sure it all appears on the screen. So you've got the client here. Okay, now they engaged a project manager, and they also engaged the builder. They've got a contractual relationship with the builder. Now the builder, because it's DNC, he engaged the building surveyor, he engaged the architect, he engaged the fire engineer. Okay, but this is where it can get, the communication between the client and the builder goes through the project manager, between the client and, well, all communication really from the project manager should go through the builder to his team as well, to his people. So these guys, David's underneath here, and Casper, who we will talk about later, was hired by the architect to be a specifications preparer. Now Newman Ashkar, he was underneath the fire engineer, and his design, I think, actually was part of why 400 people got out of the building safely. So he gets a tick. He gets a tick. But it just shows you where the relationship changes now. So the architect is now working for the builder, and all the consultants are working for the builder. Okay, and you still have the PM. All communication from the PM should go through the builder, but often he will communicate directly with the rest of the consultant team as well. He might communicate with the team and manage documentation or send stuff back and forth, so long as he coordinates with the builder's project manager, their internal people, just to make it all run smoothly. And so long, generally that can work fine. But it's what we'll look at in this document here in the ruling is the responsibilities. So this is the judgment, the verdict there. And I've highlighted a few bits, but I want to go through just some of the crucial elements here. I'm not going to go through the whole thing. I'll go through some crucial elements. So the architect advised their original client, Mr. Fraser's evidence was that Ellenberg Fraser's recommendation to his client is to go through the contract documentation phase before they go out to tender with a design and construct contract. However, this did not happen with the Lacrosse project. Now, with an architectural project, it's divided into different stages. You've got your concept design, you've got your design development, you've got your construction documentation, and at each stage, you resolve more of the design. You spend more time on it, you get it more accurate, you get more input from consultants. You have time to do it properly. But what happens is a lot of developers, clients, want to go design and construct. And the reason they want to do that is they want to get, instead of this relationship here, where our developer, where he has responsibility or risk with the design, because it's with the architect and he's employed the architect directly, he wants to shift that to him, to Jim, to the builder. And then you're thinking, well, builder can't design, they're not architects. Exactly. And the builder shifts that risk onto the architect. Okay, that's what they hire the architect. But the problem with architecture, well, being an architect under this situation is that your client's changed. You're no longer working for your original client. You're now working for for Jim here. So it can cause some issues. And you can often feel that you're ignored. You don't have the same level of authority that you had before. And that's what's brought out in this case. So the developer decided against the architect's advice to go with a design and construct contract. Okay, and the biggest issue here is, we can see again, design meeting 3. Mr. Fraser gave it evidence to the effect that the process of preparing design development documents for the tender in April was conducted in something of a rush due to rising construction costs. So you can see that the pressure the architects and the design team were on. He gave advice to the developer about the dangers of proceeding to tender with incomplete documents. Okay, and you talk to any architect, you talk to anyone in the profession, that is a common thing that happens. It's frustrating as well. So what about, there's two issues, well, there's several issues here to contend with, because if we look at the damages, the certifier, the architect, and the fire engineer have each been apportioned different amount of damages. And what I will look at is, I want to focus mainly on the architect, really, just because of the material selection, because I can relate to that a lot. But I'll discuss a little bit about the certifier and the fire engineer. And one thing that was identified very early was that the fire engineer, right at the beginning, in their fire engineering design brief, the design references listed at the conclusion of the fire engineering design brief included the FCRC, Fire Engineering Guidelines, First Edition, March 1996. It made no references to the IFEG. By the time Mr. Nichols produced the fire engineering design brief, the 1996 FEG had been superseded by both the 2001 edition and the IFEG. So the fire engineer was working or using outdated references. Now, I would imagine it would just be a copy and paste left in a document that they would use. I don't think that was intended, but it's just something to be aware of. So let's have a look at the first material schedule, because this is where it gets a bit murky. So on March 11, 2008, the architect issued the materials, fixtures, and fittings schedule, which identified infill panels as full-height composite panels over lightweight framing. Okay, so they've identified that as the material that was going on these parts of the building. That's it. They didn't specify it particularly at this stage, but that's how they identified it. And then, in March 2008, Ellenberg Fraser engaged Caspar Decker of Davis Langdon to prepare the architectural specification for the project. Mr. Fraser said in evidence that Davis Langdon is an expert building consultancy specializing in, among other things, building materials and specifications. So that's Caspar here, the specifications consultant. So he was brought on to provide additional support to the architect in preparing the specification. And that is completely normal, and nothing is surprising with that, because writing specs is a tedious process, you know. And so if we look here with so the specification revision T1 described the apartment external walls in the following terms. Infill was constructed from GAL, stud framing spanning slab to slab, refer to structural engineers documents, all linings to be constructed from 4mm composite panels supported on 32mm galvanizing. The walls to incorporate sarking, yada, yada, yada. So, you know, they're discussing the type of cladding that they're referring to. Now, what happens here, the issue here is that in the draft specification, you know, the T2 specification, this is where the architect is trying to really position their argument, because we'll read through this and we'll talk about it. The draft specification attached to that email, so I'll read through here. On the 10th of April, Mr. Engstrom sent an email invitation to Mr. Decker for a meeting to be held on the 15th of April, you know, at 8 a.m. 8 a.m. Those early meetings, that should be illegal by itself. An 8 a.m. meeting, nah. On 14th of April 2018, Mr. Decker sent an email to Mr. Engstrom attaching an incomplete draft of the specification and referred to a meeting next morning. The draft specification attached to that email included at item 2.4 aluminium cladding, with the specification aluminium sheet cladding in selected finish, concealed fixings to subframe systems, referred to the external finishes, schedules, and preliminary design drawings for details and extent. There's no reference in the draft specification to a Luca bond. Now, first off, I should probably explain what a specification is to people who don't realize. It's a big fat document, book really, that goes along with your drawings. As an architect, you prepare some drawings, you prepare models, prepare BIM model, and you prepare a specification. The specification really says all the performance requirements, the standards that you need to comply with, because you can't really fit everything in on the drawings. And why they're bringing up a Luca bond is the argument that the architect has made is that they said a Luca bond or equivalent in the material selection, and a Luca bond is a well-known standard. Now, well-known material. And I'm going to bring up here, this is one of my due diligence, product due diligence reports, because I have been bitten by what's about to happen in this project. You'll see. I've encountered this and I've developed systems to deal with it. And this is the type of information I capture with regards to approving a material. And the reason why they're talking about a Luca bond is because a Luca bond is a good material for this situation. And the A2 was classified as, you know, BCA Group 1 and, you know, non-combustible, and it's been tested to all these standards. So that's why they're mentioning a Luca bond, because that's what they are arguing, that they suggested or equivalent. And if we go down here, in the specification, this is where the architect is trying to push the responsibilities off. So the overall structure and approach of the T2 specification is set out in section yada yada yada, which includes the following. Division 1 and 8 of this specification provides general requirements applicable to the working sections. And I'm going to skip that, that's boring. But this specification is descriptive. All sections, when read with the preliminary design drawings, indicate the visual intent of the superintendent with which the contractor must comply when undertaking the design documentation. The design responsibility rests with the contractor, who will be responsible for completing the design documents, meeting any specific performance criteria, and executing the work under this contract. Okay, so this was in the architect's specification. So we need to go back here. back here. And you've got to remember, okay, this was the package that the architect prepared here, the drawings, that went out to tender and all different builders bid on it. That's a terrible square. Okay, and then one builder won it. That one builder won it. And they read this part of the tender, and that became part of the builder's responsibility. Okay, it became part of the builder's responsibility. And so they, now, Mr. Builder, is responsible for, and we'll just go through this, for completing the design documents, meeting any specific performance criteria, and executing the work under the contract. So they're responsible for that. So the architect, in this instance, he's under the contract, because it's D&C, it's been shifted to the builder. Okay? So the client now, over here, or the developer, he's got his project manager here, and I'm gonna shift colors so we can use it. He's got his project manager here, and he's got the builder who won the tender. Now he has responsibility for these requirements. Now the architect would argue he's got responsibility for those requirements, so I don't have them anymore. And that's what we've been led to believe as professionals in many circumstances, but it's not actually the judgment of this is it's not actually the case, because in this instance you're shifting responsibility, to finish these drawings, this package, out as part of the tender. But now he's won it, so to fulfill that responsibility, he hires a team of professionals. Now he didn't necessarily have to hire the same architect. He could have hired another firm over here, maybe hires a design, hires an architecture, and use that other firm to finish the design. And then that architect would have the responsibility to complete the project. Okay, they would take on all that responsibility. But the reason why you don't usually go to another architect is because you don't want to lose all that knowledge and experience that you've gained in this early stage. So the thing is, the architect is still responsible for this requirement. It's just under a different relationship, because he's now working for the builder. The builder has engaged him, and the judge talks about this later. The builder has engaged him, and so we can rely on his expertise. Okay, but here's also where it falls apart. So this is where, with regards to the inspection rule, okay, because in the tender, or in the specification, they've written it that the superintendent is the architect. But in reality, the superintendent is the project manager. Okay? Now, the project manager, he's the superintendent, and the architect is the lead consultant working under this guy. And they should also manage the rest of the consultant team here under them. Even though they're engaged by the builder, they're still responsible for managing them. And it can be quite challenging because I've been in this situation where, as the architect here, you've got to manage all these other people, and the biggest stick that you have is just a whinge to the builder. You can complain to him. And if you've got a lazy guy working in the builder, they can't do anything about it. If you hire them directly, you can hit them by not paying them. You've got the control of the purse strings. That gives you more authority than anything. But the problem is then you're taking responsibility for their risk as well. So let's have a read through this section here. It is not disputed that at the time the T2 specification was issued, the term superintendent referred to Alberg Fraser. What is less clear is whether at the time the T2 specification came to form part of the D&C contract, the term referred to the 8th respondent, PDS, which is the project manager. So clause 1.4a of the T2 specification sets out the definitions. This includes, so indicative 2, were used in relation to a manufacturer and or product reference. This shall demonstrate the level of quality required. The contractor shall ensure that all products meet the aesthetic and performance requirements specified for commencement on site. Okay, and I should highlight that because in the T2 specification, the architect has said that the contractor needs to create a product indicative to what they've specified, and they've just specified generally a Luca bond. They haven't gone into any more detail than that, and the architect essentially is building the argument that, well, this isn't a Luca bond here, A2. You should specify that one. But it turns out it wasn't. They were specifying a 100% polyethanol one. So inspection carried out by the superintendent of any part of the works under the contract. Such inspection shall be limited to an inspection of the visual appearance only, and not to the selection of materials or design documents or construction of components and equipment, which remains the sole responsibility of the contractor. So the architect was making the argument that it's not their responsibility to inspect because their inspections are only visual. But the architect isn't the superintendent anymore. Chris here from PDS was the superintendent. So he was the one that could only make the visual inspections. The architect was hired under the builder to fulfill their responsibilities under the contract. The sole responsibility of the contractor. So they're kind of, the contractor wants the best of both worlds here. So if we go here, so this is in discussion about the Aluka bond specification. It is far from clear who was responsible for the Aluka bond specification. Neither Mr. Engstrom nor Mr. Decker was called to give evidence, and Mr. Fraser's evidence on the issue was at best equivocal. In his witness statement, Mr. Fraser appeared to attribute the decision to Mr. Decker. I believe Aluka bond was nominated in the specification by Decker as a protection because Aluka bond was a well-recognized cladding system that was used extensively in good quality projects. The specification required the builder to use a product indicative to Aluka bond because it was a top-of-the-range product that had a reliable warranty installation system. At the time, composite panels were approved for use on buildings, including high-rise buildings like the Lacrosse building via the alternative pathways provided for in BCAC 1.12. A particular Aluka bond product was not specified because different Aluka bond products appear appropriate for different installations. Okay, so hear this. Oh, let's just dwell on this. They didn't actually specify a particular product. They just said this brand. Okay, they just said this brand. So, however, in his oral evidence, Mr. Fraser seemed to want to make the point quite forcefully that he played a critical role in the choice of product. That evidence is set out below as part of the consideration of claims against Elberg Fraser. The effect of the evidence is that it was Mr. Fraser who directed that the T2 specification specifying the Aluka bond brand. However, he was not aware that the T2 specification would state indicative to Aluka bond. He said, I thought we were going to get an Aluka bond system with all of its proprietary details and technical data. So the specification said indicative to, so as equivalent, essentially. That's very common in the D&C projects. Very, very common. And this is the trap. This is the trap that's got the architect, because they've specified it with insufficient information. But the problem is they were rushed as well. The fees were probably, well, no, the fees were good, but, they were rushed, and it happens quite often. So they didn't say a specific thing, and he thought he was getting a Aluka bond. He could have just specified it. So we look here, Mr. Auld, nope. Essential safety measures. Okay, this was to do with the balconies. We'll go here, the certifier. So no one informed LU Simon, informed me, this is the certifier talking, that LU Simon had decided to use a substitute product, Aluka Best, for the aluminium cladding. Had I been informed that LU Simon was intending to use Aluka Best, I would not have issued a Stage 7 building permit. So the certifier issued a permit. He wasn't aware that there was a change. Now, this is where it all falls apart, really. And we need to go through this about the approval process for the samples. Okay, and I think this is what every architect, every designer, every builder needs to be aware of, these issues. So the Alucobest sample approval. Early on the 24th of May 2011, Mr. Early on the 24th of May, Mr. Visalikis, L.U. Simon's contracts administrator, sent an email to Mr. Palmer stating, "I'm about to courier a sample of the proposed metal cladding for the East Tower to you, along with our samples submission form, as discussed with Dino yesterday." I love the fact that he's talking, Dino, it's a construction project, This was followed by a letter from L.U. Simon sent by courier enclosed with the Alucobest sample. The letter stated, "Further to your conversation with Dino yesterday afternoon, please find enclosed a sample of proposed composite cladding with metallic silver finish and sample submission form for your sign-off by you if satisfied with the sample. Please note that it is 4mm thick sample as discussed yesterday. If you could return these to us by courier, it would be greatly appreciated. Otherwise, please bring them with you to our design meeting tomorrow. Thank you in anticipation. Should you have any queries, do not hesitate to contact us." Okay, so notice how they're putting the time pressure on him. They're probably putting the time pressure on the architect to get it done as quick as possible. We need this approved, we need this approved. And they will do that to you all the time. You'll cop it all the time. You'll cop it from the project manager, you'll cop it from the builder. They'll lie to you to say, oh, it's a delivery issue. They won't order something until the last minute, or they may just bug it up. So you'll be under pressure here. So before we read on, you just need to be aware that the architect making this assessment will be under pressure. The letter also enclosed an L.U. Simon form titled Sample Submission Form. Gardner Group submitted that L.U. Simon issued the sample submission form for the Alucobest product as an alternative product. Okay, so they're saying that it was an alternative, but they didn't provide the original. However, the sample submission form as sent by L.U. Simon and referenced by Mr. Galanos' submission does not in fact have either an option on the form being as specified and alternative circled, so they didn't complete the form. So later in the morning on 24th of May, Mr. Palmer sent an email to L.U. Simon confirming receipt of the sample and stating that, so this is the architect, the color of the sample is acceptable. Could you please confirm that the Alucobest composite panel meets the warranty and other requirements of the specification? Pending this information, we will confirm that the 4mm sample is acceptable. Once I received it, I will return the completed samples submission form. So he's agreeing to fill out the form they've provided, but he wants additional information from them, which is fine. This is the problem in design and construct projects. A lot of architects are apprehensive to do too many specifications of materials because, frankly, it always gets changed. They'll find a best buy or cheaper version, which has happened here. So, by reference to this email, Mr. Palmer agreed in evidence that he was concerned about the color and that he was also concerned about the warranty and that he asked about the other requirements of the specification. Okay, so remember that the superintendent was only originally meant to just do a visual check, but you can see here he's been a good architect in asking about these other things that is required. Okay, because I'll go back here to this. You want to see, what's the fire rating? You want copies of certificates. You want all this evidence. You want the warranty information that you can get here and compare it, and additional notes about it. You need all of this stuff because all we can do as architects is request the information and base our decision on that. That's all we can do. We can't test the materials ourselves. It's unreasonable to expect us to go and okay, I have taken some of this stuff and hit it with a knife to see if I could get through it, but that was more fun. You can't do a laboratory experiment as an architect. That's not appropriate for them to expect us of that. So it was fair and reasonable for him to ask for those things. I would expect someone working for me to ask for that additional information. But here's where L.U. Simon uses that against their argument that they were only inspecting it visually. So importantly, Mr. Palmer agreed that when he sent this email at 11:42 a.m., he was not prepared to approve the sample even though the color was acceptable. That means that Mr. Palmer was not confining his approval to color. So much is no more obvious now than it must have been to L.U. Simon in 2011. Okay, so let's just dwell on that. Because he was asking for this other information, they can use that as a position going, well, he was obviously doing more work than, or he was obviously assessing it more than just visually, which was only the superintendent's responsibility. Okay, and I can understand both sides. I can see exactly where the architect is coming from. And I've been bitten with this as well, where we had a job where we'd specified scope fridges, and the architect or the builder changed them out for, exactly the same equivalent from China. And one of my staff looked at it, reviewed it. Yeah, it kind of looks the same. Ticked it off. It didn't fit. It was 100 mils more, so we had to adjust some joinery, and we got it sorted. But it just shows you, and that's why I've developed, a process like this to really go into detail about all of these things. Like this is a drainage system, and I'm not bringing any of these to show particular products. I'm just bringing it up because I could find the files easy. Here, for this example, one thing that you want to check is always the slip rating and the two different types, because they've changed as well, and the loads that they can take. Just for this type of thing, this is the type of information as an architect you need to go into. But the problem is, it can take a lot of time to get this stuff. So you know what I do? Personally, I don't give a crap about any submission form they give me. I'll just throw it out and ignore it. And then I'll send them a blank one of these and going, I need all of this information filled out in my form. I actually made a PDF that they could fill out and they could send it back. Because as an architect, if you're working under design and construct contract and they want you to review a recommended material or an alternative material, that's a variation. You can charge extra for that. But the problem is, when you do that, it creates animosity between your firm and theirs. If you start charging them for variations, you start playing the game, and that can cause issues. It's fair and reasonable to ask for it, but it can cause problems going along, and that's just the difficulty of these situations. You want to keep everyone friendly, you want to be nice, you want to keep it all moving, you want to be a problem solver, but it can cause issues. So let's get back to it. So yeah, here we go. In mid-afternoon, Mr. Visicalis of L.U. Simon sent an email to Mr. Palmer stating, David just received a Lucabest warranty terms, which are 15 years in accordance with the specs and head contract. Mr. Palmer agreed in essence. This email was confirming to him that the Lucabest composite panel met the warranty and other requirements of the specification. So he trusted the email from, I'm going to call it Mr. V, that it was sufficient, that it met the same requirements of the Alucabond product that they specified. But did he get evidence of the testing? Did he get certificates proving that it met the requirements? Did they even check what the materials were in it? I mean, okay, this was done in 2008, so probably wasn't aware of the issues with the materials. Visually, it probably looked the same to an untrained, to a non-material scientist. It looks the same to us, and I can completely understand making that decision. But he approved it. He needed more information. That's why, as any architects watching this, you need to establish your own, proper product due diligence. And if you want, I've got a database I'm willing to sell very cheap. Send me an email. I'll turn it into a product and you can download it. But you need to have something in place so that you can send out and put the responsibility to confirm that back on them, back on the builder, or saying, I need this information to fulfill my responsibility, to meet my obligations under the contract that has been pushed to you, but they've been pushed back to me because I'm working for you now. I need this information. And if, this may have gone a completely other way if they said, I needed all of this information and the contract that never provided it for me, Judge. What could I do? There you go. So Mr. Palmer then signed the L.U. Simon sample submission form and prepared an Ellenberg Fraser Architect's Advice, number AA061, dated yada yada yada, and identified as being 2 Mr. V and 3 other LU Simon employees. The advice included a note from Mr. Palmer to Mr. V that the Alucobest sample provided is approved as per the attached approval. The attached approval was the LU Simon sample submission form as originally sent by Mr. V, now bearing, in addition to Mr. Palmer's signature, the date and the annotation confirming 15-year warranty in line with asbestos advised. Okay, so there you go. There you go. They approved it. So let's have a look at this point here. So it appears that the version in the evidence that the person signing for PDS, okay, PDF signed off on it, but all they had to sign was the visual. They were the superintendent, so they really should be just ensuring that it visually meets the requirements of the concept design or the design development that was issued as part of the tender. That's what they have to cross-check, and they would understandably be dependent on the architect who's now working under the builder. You can see how this gets all very murky and messy to ensure that that's compliant. But the problem is here, what if the builder made a change that the architect disagreed with, but because the architect, and I'm going to use this here, and this is the problem of it, because the architect is now working under the builder, he really shouldn't communicate directly with the project manager. Okay? He needs to communicate through the builder, and the builder needs to transport that communication onto there. He can, if he wants to risk losing the contract or potentially being breach of contract, depending on how strict they are with the communication protocols, he can inform the project manager of a breach or of the builder doing something he's not happy with. But sometimes also these guys can be working together, and you may not be able to. You could probably go to the original client, but they may not want to hear you. They may not have the expertise here to appreciate what you're telling them too. These are all things that open up when, as an architect, you're working in this position, and it is quite frustrating. Now, here is another thing. With this approval process, with this material that was specified, that he didn't, he should have also sent this material. The architect should have sent this sample on, before he approved it, to the rest of the team. The certifier and the fire engineer should have also been provided. This is the material that they're approving. They need to also put their advice in, and it looks like they didn't. They weren't provided with it. So here we go. In relation to Gardner Group, LU Simons has submitted that Mr. Galanos inspected the works during construction, that he must have seen the Alucobest when he was shown photographs of the building under construction. In evidence, he accepted that the Alucobest name was prominent. However, his evidence was that he did not see it at the time. So this is that the certifier should have known about it. The certifier should have known about it because he walked on site and saw it. What I think has happened here, what I think has honestly happened here, is that the architect, and this is I also have this frustration when I'm working in this situation, because the problem is the builder will start issuing instructions to everyone, or the project manager will start issuing instructions to everyone. Okay, so then they're still arguing that the architect should have informed these other guys of everything else that was changed, when you're not even able to communicate with them directly, or your authority is being undermined by other parties communicating with them directly. Or you would assume that because the builder is issuing other instructions, or the project manager is issuing other instructions to other parties directly, that they would also get their input into the material. One way would be in your response going, as architect, I tick off on this alternative material. Could you please confirm that, ensure that you've got approval from the building surveyor, from the fire engineer, from that. This is the problem. This is the processes that we need to go to now as working in these type of projects. Okay, so another issue. So, and this is one of the biggest ones as well, to do with the buildings. The balconies could not be used for storage, essentially. And the builder argued that because the balconies were used for storage and the certification, the certificate of occupancy or certificate of classification was issued without specific instructions on it saying that they couldn't be used for storage, that increased the spread of the fire. And the judge agreed with it, essentially. And here we're talking about the issue is with the ACP, the Alucobest, was the 100% polyethylene core, as opposed to, you know, the fire-rated one, which is like 90% not, you know, other materials. So it isn't flammable, but this one's just, you know, stuff you pack your bloody computer screens up on. And here they actually talked about specifying the Alucobond product, the A2 product. And the reason I'm bringing this up, because I've had the same thing on a job where we specified an alternative and we had to look for something that met fire requirements. And it has a 90% mineral core, but it's more expensive. And essentially the argument was kind of wasn't relevant because the original product that they specified was just the Alucobond, so it could have been 100%, pardon me, polyethylene core. So one thing though, the experts argue that the 90% mineral core would have prevented the escape of the fire from apartment 805. So this is one, Dr. Clancy. I'm just going to read this bit because it relates to jobs I've worked on. So Mr. Hughes Brown was not cross-examined on the contents of his report. The other fire engineering experts were asked this question. Mr. Kipp was unwilling to express an opinion due as not being briefed with sufficient information, while agreeing that the use of an aluminium composite panel with a 70% mineral core, such as Alucobond Plus, or 90% mineral core, such as Alucobond A2, would have slowed the spread of fire. Dr. Barnett and Mr. Wise's answers were to the same effect. Dr. Clancy said that he was 90% confident that the use of an aluminium composite panel with 90% mineral core would have prevented the escape of the fire from apartment 805. So if they had specified this product exactly on the drawings and it was built with you know, some experts are saying it would have been a 90% chance that it would stop the spread of the fire. But if they had spec'd it, you know, even they've gone, okay, they spec'd A2 exactly how they wanted, but the builder still put a Alucobest to them and they still approved it the way they did here, they still would have been deemed to have been in breach of performing their duties. Another issue was that the smoke detector was covered in aluminium foil, which, you know, delayed it. And the judges argued that the builder was acting fit for purpose, and they were essentially dependent on the. They took reasonable care, and they were dependent on the architect's professional skills. So I consider that L.U. Simon's relationship with each of the other building's professionals is analogous to that between a developer and a building professional. In Barryman versus Hames Charlie, Proprietary Limited, Hasluck J. rejected the architect's allegations of contributory negligence, finding that the client developer was dependent on the architect's professional skills. Okay, guys, so for all the architects listening to this, this shows us that in a design and construct contract, you can't shift your responsibilities onto the builder. Even though you have to deal with all the pain, probably less fees, it doesn't mitigate any of your responsibilities here in this case, in this circumstance. So that's really quite concerning because D&C fees can often be quite low, and you're expected to do a lot. You are expected to do a lot, and it's really worrying actually for the profession. And we've seen in the Shergold Weir report just the conflicts of interest that are prevalent there. You're seeing here where The architect doesn't have the authority that they traditionally have in this circumstance. So, we don't know if they were pressured or pushed, or they really didn't appreciate the level of responsibility they still had in this issue. And this is something that all architects need to be aware of. And clients should probably just pay for better documentation to begin with right at the beginning, because the developer, pushed them to be cheap, cheap, cheap and go fast, fast, fast. And I think that contributed, frankly, to some of these issues, to not a thorough assessment of the alternative material that was proposed. So the certifier was also considered to be professionally negligent in this case. And, there was a failure to exercise duty of care. So I think that is enough to get an understanding of it, of the case and what happened. I can go into greater detail here, but it doesn't really. Essentially, the architect was responsible for certifying it. You can't. Even the novation process, it's an entirely new contract. The first contract needs to be essentially removed, and you have to understand that you're responsible for these things. And from a professional perspective, the best way is to set up processes in place and to push that information requirement back onto the other parties, push it back onto the contractor. But the problem is, you may be unpopular, but you've got to do it because they were awarded all the damages, or a portion of the damages in this case, the three of them. And you still need to communicate to all the other consultants. It's tough, it's frustrating. In many ways, it's not fair. And yeah, I'm a bit frustrated with the profession at the moment, honestly, with where this is all heading, because they want to have that, they want to have their case and eat it too. Like here, the specification didn't negate their risk, because that specification was dealing with the relationship of the contractor to the client, the developer. It had nothing to do with the relationship of the contractor to the architect. They're pushing all that issues back onto them. Novation is simply to ensure that finally it must be remembered that the deed of novation, Elberg Fraser agreed that it would be liable to L.U. Simon with respect to the performance or non-performance of the services under the EF consultant agreement, whether such liability arose under the law of contract tort or otherwise, including without limitations liability for any defects, including latent defects in the services, whether those services were carried out or performed before or after novation. Okay, so they're liable even for what they did before novation. Bloody hell. Bloody hell. Let's look at the judges arguing that D&C does not limit the architect's responsibility. As I've made clear, it is no answer to these findings of breach to point to equivalent obligations owed to L.U. Simon to the developer under the D&C contract. Elberg Fraser's argument to the effect were a time-consuming and unnecessary distraction in the proceedings. I accept L.U. Simon's submission to the effect that what it was seeking to achieve in engaging Elberg Fraser under the terms of the EF consultant agreement was to shift back to Elberg Fraser responsibility for ensuring that L.U. Simon complies with these obligations. So this sums it up here. Fraser was still had these, even though their original documents shifted that responsibility onto the builder under the D&C process, they were the architect that the builder hired to fulfill those responsibilities for. It's that simple. And I feel sorry for them. I feel sorry for all the architects involved. I hope I haven't been rambling too much going through this. I'm pretty exhausted, to be honest. And one last thing we'll look at here about the project manager. And, I won't go through all of this, but essentially they argue they were satisfied that they did not breach their responsibilities under this because, they were just the superintendent. They weren't the professional engaged. So it's a tough situation to be in, guys. I recommend for architects listening, for any consultants listening, you need to have thorough paper trails. You need to have databases in place to allow your staff to implement these processes really efficiently, really easily. And for buyers looking at these apartments, you want to ask for evidence of just materials that they've done. Make sure, see if they've used a Luca Best. Make sure that you want materials that aren't 100%, polyethanol. Glorified polystyrene. You know what I mean. So guys, thank you for joining me for this episode. I know it was long and difficult, but I mean, I'm going through judgments. How exciting can I make it? Let me know what you think in the comments. Do you think it's fair what the judgment was? Do you think the builders want to, have their cake and eat it too? Do you think D&C fees are sufficient for this? Because honestly, certifiers, fire engineers probably aren't getting paid enough to check every single material, to duplicate all the work. You have to depend on each other on the team. And I can appreciate where it's coming from. I really can. But in the end, I would have to say I agree with the judge's call. I do. Guys, thanks for watching. Like, share, and subscribe. Ding the bell, and let me know what you think. I'll see you tomorrow, hopefully with something a bit more fun and less exhausting. Bye for now.